Yes, welcome to the No State Project, live from the fortified compound in Mesa, Arizona, where we are at the beginning of a haboo. So, yeah, I'm not making that up either. A haboo. It's a number of years ago, I started hearing that phrase when we got these enormous dust storms. So it is about 115 degrees still at 7 o'clock p.m. And we're not going to get rain, but we're going to get a lot of dust to get everything even more dirty over there. I mentioned last week, glad everyone's tuning in. For those not watching the live stream, and as those fill in, if you want to help support the channel, like I mentioned last week, so I could do more frequent, more regular streams, then you can do so in the comment, in the description below. And spoke last week, big topic. I've spoken about this an awful lot. It goes hand in hand with prosecutorial misconduct. So we're talking about Brady versus Maryland, Brady material. What is Brady material and why is it essential to a fair trial? Because it is essential to be able to defend myself, effectively defend myself, and have a fair trial that the prosecution, the plaintiff's attorneys, that they disclose everything relevant and material to me. And so Brady material in particular has to do with exculpatory evidence. This is evidence that shows that you're innocent, that it may be somebody else who committed the crime in question. So I've done whole shows on this, and this doesn't give us all of them. I only did a search for this piece of garbage here, Stephen Myrie, and this is just an extreme. I'm not saying that all prosecutors are guilty of prosecutorial misconduct. Well, I would say that the majority of them probably are, and especially if the opportunity was to present itself, that most prosecutors would probably withhold exculpatory evidence, going by their gut feeling that they got the right guy. So, Stephen Myrie, holy crap. Stephen Myrie was a federal prosecutor. And I'm not going to play all of this, of course. And yeah, I killed it with the views there. I know somebody will probably have to do that. But here, not that I'm a fan of the Bundys, but judge throws out case against Bundys, bars retrial with stunning rebuke to federal prosecutors. Navarro admonished government for flagrant. Okay, these are not my words. So I mean, I was quoting them here in their title. Flagrant prosecutorial misconduct for withholding evidence. Now, there's not a lot of pictures available. Typically, of federal prosecutors, you're not gonna get that. But this is the piece of garbage, Stephen Myrie, right there. And if I remember correctly, I should have a picture of him as a young man. There he is. I think he's in college here. There he is. Yeah. So these were the only known pictures of this piece of garbage, and this is going back. I don't even have 1,000 views in 5 years. I mean, you guys are always screaming the loudest that I talk about veganism. I talk about court. That's just sad. So I guess the interest. Maybe I should have looked at that before deciding to do a show on Brady material, which might get 4 views. Wow. Stephen Myrie, that was my edit. Most likely to engage in flagrant prosecutorial misconduct. There he is. All he didn't do any. What he did was he withheld hundreds and hundreds of documents that tended to show that the defendants were innocent. And I think in this one, specifically, they had to do with documents that showed that the Bundys were not a physical threat. I'm not casting any judgment on that. It was 5 years ago. So he didn't do any time. He didn't lose his job. I think he lost a promotion. The man should have been put in prison. The judge should have just said, if there was any justice here with these pieces of garbage, Stephen Myrie would have been just getting out of jail. Because if you are willing to withhold hundreds of documents against a single in a single case. That's a. I'm going to go on a limb here and say that this SOB, that was not the only time he engaged in it. You know, that if it was a historic, unprecedented escalation to go from squeaky clean to flagrant prosecutorial misconduct and just skipping over everyday prosecutorial misconduct. It's always good to have this piece of garbage, his face and his deeds remembered. There may not be a lot of pictures of him, but we know his name and we know what he did. And my gosh, to have a federal judge call you out for flagrant prosecutorial misconduct, boy, you know you stepped in it. So what the hell is Brady material? Let's go through this. It's it was 1963. It was established it was a case that established the prosecution must turn over all evidence that might exonerate the defendant, which is called exculpatory evidence, to the defense. Disclosure, as I've mentioned before, so I like in My Cousin Vinny how it came out. It's called disclosure, you dickhead. They didn't teach you that either. My Cousin Vinny, what a movie. The prosecution failed to do so for Brady, which is to give the disclosure. What they have and what they're using against you to prove beyond a reasonable doubt that you did the alleged crime. Brady challenged the conviction, arguing it had been contrary to the Due Process Clause of the 14th Amendment to the United States. So, to be able to adequately and effectively defend myself in court, the courts have ruled that since I'm entitled to a fair trial, to be able to do that, I have to know. I can't have surprises. I have to know what the prosecution is using to prove their case. And through their investigation, they're going to come up with a lot of information. Maybe there's a witness that is, let's say you have 15 witnesses to an alleged crime, and 12 say, I saw the guy do it. But 3 say, I didn't see the guy there. You can't hide those 3 witnesses that are giving exculpatory evidence. They're giving testimony that shows that you're not guilty. You have to disclose that. The defense has a right to know about all those witnesses. And for to have a conviction come out and then it comes out later that they didn't bring in 3 witnesses that had contrary testimony, yeah, that's denial of a fair trial. The Supreme Court held that withholding exculpatory evidence violates due process where the evidence is material either to guilt or to punishment. And that word right there it has probably launched more episodes of prosecutorial misconduct than any other word there. Because someone like Stephen Myrie, Your Honor, me and my team, we concluded it wasn't material. So they use that. So in my experience, when I've read these cases, and I've seen it firsthand in court, that is the word that they hang on. Well, come on, Your Honor, we had 12 witnesses that said the guy was on Maine. And 3 that said he wasn't. We didn't deem it material. So that's where a lot of these things hinge. The court determined that under Maryland law, the withheld evidence could not have exculpated the defendant, but was material to his level of punishment. Thus, the Maryland Court of Appeals ruling was affirmed. William O. Douglas wrote, "We hold that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment." Society wins not only when the guilty are convicted, but when the criminal trials are fair. The defendant's request for Brady disclosure refers to the holding of the Brady case and the numerous state and federal court cases that interpret its requirement that the prosecution disclose material exculpatory evidence to the defense. Exculpatory evidence is material. This is important. Whoa. Oh, those pesky footnotes where everything is shown, where the sources are here on Wikipedia. I'll try not to do that again. Exculpatory evidence is material if there is a reasonable probability that his conviction or sentence would have been different had these materials been disclosed. Now, I've mentioned before where a denial of cross-examination without waiver would be a constitutional error of the first magnitude, and no amount of showing a want of prejudice would cure it. A lot of cases on that. It's actually in the book. I quote it many, many times. Can't think of it off the top of my head, but that's almost an exact word-for-word quote. So they do have an opportunity to deny cross-examination if it's cumulative. So if you have 15 witnesses all testifying to the same thing, and they don't let you cross-examine 2 or 3 of them, they've let that go. I don't know how often. I just know they've let that go. So Brady evidence includes statements of witnesses or physical evidence that conflicts with the prosecution's witnesses, and evidence that could allow the defense to impeach the credibility of a prosecution witness. There is a big one right there. Impeach the credibility. Witness impeachment in the law. All right, so like Rule 602 is the federal rule, and a lot of states have adopted that. Now, whether it's Rule 602 or a different number, it's essentially the same. The witness has to have personal firsthand knowledge of the matters they're testifying to, and that is a way to impeach a witness. So in the law of evidence in the United States is the process of calling into question the credibility of an individual testifying in a trial. The federal rules of evidence contain the rule R. So that is really allow the defense. We'll highlight that. Someone mentioned in the comments last week that there was a recent Supreme Court case regarding Brady, and I could not find it. The best that I could do was this, and it is Green versus Dixon. Oh, out of Florida. What a surprise. This is an amicus brief, so this is not a decision. I couldn't find a final decision posted. There's good stuff in here. They're quoting directly from the Supreme Court. From their own experience, amici, it should be amici, yeah? No, it's Latin, so amici. Understand that the duty of prosecutors is not of an ordinary party to a controversy, but of a sovereignty whose interest in a criminal prosecution is not that it shall win a case, but that justice shall be done. Yeah, because they adhere to that. As the court recognized in Brady v. Maryland, a prosecutor's failure to disclose the exculpatory information in a criminal to a criminal defendant prior to trial violates due process, irrespective of the good faith or bad faith of the prosecution. So that's good to know, because if they feign a good faith argument that they didn't think it was material, it doesn't matter. Failure to disclose is still grounds to overturn. I think I'll blow that up mainly. So these are good arguments, and they're consistent with Brady, but I don't know if they won. I do have to point out before I talk about impeachment and how I use this. The guy in the thumbnail, he's not actually in this, but the guy. All right, let me do this. I'll go back so I can so you can see the scumbag in the thumbnail. See if he's going to be in here. That's the guy. This is amazing. It's a few years old. Dallas County ex-prosecutor disbarred for withholding evidence after 2 wrongful capital murder convictions. So you talk about 2-tier justice system. There's no information that this piece of garbage who withheld evidence in a capital murder in wow, that's insane. It's great. It's great that this scumbag was disbarred. But was he prosecuted? He withheld evidence that led to the wrongful convictions of two men who spent 14 years in prison in the fatal stabbing of a pastor. He surrendered his law license last month, and this is in 2001. The State Bar concluded that he failed to inform Dennis Allen and Stanley Mosley's defense attorneys about evidence that could have cleared them at their capital murder trials in 2000. This case is not about someone disbarred from and the guy's name is Rick Jackson. This case is not about someone disbarred from I'm getting the impression I gotta make that larger. At 94 degrees, it's 20 degrees warmer here in Phoenix. This case is not about someone disbarred for making a mistake or a prosecutor who accidentally or even sloppily failed to turn over favorable evidence. Nina Morrison, a lawyer with the Innocence Project in New York, who worked at Clear Allen, told the news. This is someone who repeatedly and intentionally hid favorable evidence from two defendants who were on trial for their lives. He's not in prison. Oh, the individual attorney uses law license, so he can't practice law. Rich white guy. Well, probably a fairly well-off white guy who is very privileged. This guy was a prosecutor, for heaven's sakes. Ruining people's lives. And walks free. I found nothing about this guy being prosecuted. This is where the Innocence Project website. Absolutely sickening. I guess it's good to be one of the king's men. So, where I used this and was successful was requesting in discovery the evidence that the prosecution relied on, that the police officer or the tax agent relied on to support their legal conclusions against me, which formed the foundation of the prosecution's case, without which they could not find a violation beyond a reasonable doubt or by a preponderance of evidence if it was a minor traffic ticket. Now, I've had a lot of tickets thrown out that after I put in the discovery request, the prosecution has withdrawn. Either the evidence is there or they don't have, so the prosecution has to know, and they have to do a reasonable inquiry into what the witness is going to test. I mean, they're prepping a witness. You have to know what, when you're first doing an initial interview, you have to know what the evidence is. You have to know what they're going to testify to. Are they qualified to testify to that? So whether they're a cop or not, the prosecutor's job, any attorney's job, or anybody who's defending themselves, my job would be, if I'm going to call a witness, I have to know that the witness is qualified. I don't just put him on the stand, him or her on the stand, and then determine whether they have personal firsthand knowledge. I got to know before I put them on the stand. And it's part of disclosure, as you can clearly see. This is Brady material. So when I would ask for the prosecution's evidence that they relied on to prove the legal conclusions against me, to support those legal allegations, reason dictates, and the rules, they are supposed to provide me that information. Now, if they don't have it at the time they receive it, they're supposed to do an interview with the witness. All right, let's sit down. What do you got? Now, we know when it comes to this kind of evidence, well, there is no evidence, but we know when it comes to supporting that and providing that kind of material, when it is like in Arizona, when it's a minor traffic ticket, we know Pierpan. Pierpan was the judge Mike had in Scottsdale, and I couldn't remember it a few weeks ago. Pierpan. We know from personal experience, I've witnessed this in Pierpan's court. You're supposed to get the discovery in a civil traffic case in Arizona, civil in name only. you get it immediately prior to trial. Well, with peer pan, when we were there last for Mike, I asked the police officer for the evidence used, in the discovery request that when we had asked, and he said he was going to let peer pan handle that. Now, again, I will say that peer pan did not handle that well. He was a little upset with the police officer, but a lot more upset at Mike and I. Actually refused to conduct a trial and had Mike put down as a no-show. So, anyway, if you do a search on my channel for peer pan, you should be able to find that. Gosh, 961. Oh, it's a few thousand there, a few thousand. Well, that's kind of sad. Kind of sad. So what I'm going to do in the remaining, so that's Brady material. Brady material is exculpatory evidence. Evidence that can be shown, that can show that the defendant is innocent or not guilty of the crime charged against them, and it must be disclosed to the defense so that the defense can adequately and effectively defend themselves. So I'll go out on a limb here and defend defense attorneys, because Larry Krasner, yeah, I'm another show where I'm naming Larry Krasner. Defense lawyers, and hopefully nobody out there will ever need one. Defense lawyers, to be able to effectively defend their clients, have got to have full disclosure. So just like Mona Lisa Vito said, it's called disclosure, you dickhead. They didn't teach you that either. That's why it's so important. You have to have that evidence to be able to build the defense and effectively defend yourself. So what I'm going to do is I will go back to that so that I can now go to the comments for the last remaining part of the show here today. So let's take a look. Sixth Amendment nature and cause of the action. Brady request. Yeah, Brady request. Mark, please give us the definition of reasonable that is used 100% of the time. I don't think there is and it's it's kind of circular. Reasonable be what a reasonable adult would do in that situation. It kind of depends on the jurisdiction, the court. Even an officer's personal record with the department. Now, yes, they're because I mentioned last week, test the lying. There are some police departments and jurisdictions that keep a list of Brady cops. So Arizona is a bit easier for a defendant to get that information. It's extremely difficult to get into a police officer's file in California. Of all places, California, you think would be, it wouldn't be but I guess they got a really strong union there. It's exceptionally difficult to get into a police officer's file in California. Who gets to decide what's reasonable and what is not? Part of it comes down to, like I read in the document, it comes down to, is the information material? So would it have changed the outcome? So obviously, if you've got, in my example, if you've got witnesses, 12 witnesses for the defense and 3 witnesses that say he's innocent through their testimony, that would be material that the jury should absolutely have that information and should be provided to the defense. Where is my written guarantee of actually getting a fair trial? There is no written guarantee. You can say that the Constitution guarantees every defendant a fair and impartial hearing. Someone's saying here, file a UCC1. I'm going to go out and give some legal advice here and say absolutely under no circumstances do the UCC stuff. So hopefully that's not going to make me a target again for the bar, but absolutely never file a UCC. That stuff is ridiculous. A bond from the Fed? Come on. Give me come on. No. no, that's just yeah, please do yourself a favor. Ignore this crap about the UCC stuff. Don't do the UCC stuff. Aloha, have you ever had an NDA from court? I have not had a non-disclosure agreement from the court, but I do have the distinction of working with a number of people. I've mentioned in one situation from a client in Connecticut. Yeah, almost done. A client in Connecticut. I was working with a Connecticut attorney who did Libertopia, by the way, and he was disappeared. The U.S. attorney would not communicate. And it's the Connecticut office. The guy. Aaron Schwartz, the same prosecutor's office that drove Aaron Schwartz to kill himself. What they did was they took the guy and they would not disclose to his attorney. Again, a regular licensed attorney the guy who did Libertopia, and wouldn't communicate with him. And part of his agreement not to go to prison was to never communicate with me and the attorney again. And there have been several others where part of their agreement was they had to cut. I actually did a show with somebody in Salt Lake, and he was raided, and for them to just take money from him and not seek a prosecution, part of it was no communication with me, and I of course found that out through a third party. So that was that. So me personally, no, I don't see any reason why I would need a non-disclosure agreement from the court. It's supposed to be public proceedings. So, and what I described was pretty extreme. So what happened with the guy in a tax case in Connecticut was horrible. We didn't know what happened to him. And I even spoke to the U.S. Attorney's Office and tell him he has an attorney of record. This is his name. This is his bar number. He's licensed currently in an attorney in good standing in the Connecticut bar. He's got counsel. He has counsel. But they wouldn't communicate with him at all. So, and his indictment did not show up on the U.S. Attorney's webpage. So we were totally in the dark. So it was years before I found out what happened to that guy. So, yeah, which is really, that was pretty extreme. So anybody, so that goes, that's as bad as this Stephen Myrie scumbag. Oh, you can't see that now. All right, I got the official message that to wrap things up. A lot of material that we are able to cover today. If you have any questions, leave them in the comments. If you have any ideas you want me to continue doing this kind of stream on Wednesday or next Monday, let me know. If you have another suggestion, let me know. Hey, if you want to talk about veganism again, happy to do that. Let me know in the description, and use the links in the description if you want to help support the stream so I can do more frequently, more consistently. So I'm going to end it there. Appreciate everyone tuning in. I will be back on Wednesday, weather permitting. Same time, 7 o'clock